Good morning. We thought you were signaling us.
No, it kept ringing. Sorry.
Yes, okay, it was ringing.
Yes.
Is everybody here?
Is everybody ready?
Not at the moment, but we will be in just a few moments.
Well, we can just sit here at ease. Thank you. My fault. You know, now that you mentioned it, I heard it keep ringing, and I thought, well,
Okay.
it's ringing.
Goody.
Thank you.
And can we ask the appellant's attorney, are you prepared to proceed, or do you need a couple of minutes?
I'm ready.
Okay. Great. Thank you for your courtesy and standing for us. We appreciate it, and good morning. We are here for oral argument on JM Homes versus Empire One Builders. Our cause number 1CACV140179. We have reviewed your arguments. We've conferenced the case. We I'm sure, have some questions, and we appreciate your coming and arguing to us today. And with that, we'll start with Mr. Tafoya. If you want to save some time for rebuttal, you probably know how this works. We need you to watch the clock and tell us when you're ready to sit down, and we'll try to honor that, before your time is up. And finally, if you would each identify yourselves for the tape recording, or the electronic recording, rather, that would be helpful too.
Just showed your age.
Tape recording, yes. Okay, so
Oh, no, I understood him.
I trust I pronounced that correctly, Mr. Tafoya.
Yes. Good morning. Michael Tafoya for the appellant. I'd like to reserve 10 minutes for rebuttal.
All right.
And I am content with the information I have on the brief. If you wanted to get directly to questions, that's fine. If not, I have 2 points that I want to make related to the respondent's brief.
We don't need you to run through the facts, although we may end up with some factual questions. But yeah, go to your points if you want.
Normally, you would wait for rebuttal time to respond to any arguments that are made. As far as the other side, do you want to just reserve unless we have questions, do you want to reserve all 19 minutes and 22 seconds for rebuttal?
That would be fine.
All you're going to do is address rebuttal? Or do you want to do it now and reserve some time?
I'd rather do the 2 points now because they relate directly to what's in the brief, and then reserve the remaining of the time for what happens at argument. Unless you have any questions, I'll start there. The first is on the issue of who was the owner of the property. And in the appellant's brief, we talked about Victor McCleve being the owner of the property, and that it wasn't unusual for him to contract directly with a contractor to do work, in this case, the work on the driveway. The counter argument to that brought by the appellee was that Victor McCleve was not actually the owner of the property. And there are 2 problems with this. First is a threshold issue. That isn't really an issue that's an appeal. The administrative law judge found that Victor McCleve was the owner of the property. The appellee didn't. I'm going to go with the contractor or the subcontractor. JM Empire, the subcontractor, didn't seek administrative review of that, didn't seek cross review, didn't file a cross appeal. So that's a decision that was made a long time ago, and it's never been raised on appeal before.
Does it make any difference in your view who owned the property?
Who in reality owned the property doesn't make a difference.
I'm sorry, does or does not?
Does not make a difference. Who they believed owned the property at the time the transactions were entered into makes a difference, because it goes to the question of apparent authority. In this case, Victor McCleve was out on the property. He owned the property. Empire Builders believed he owned the property. And Victor McCleve then contracted with Empire Builders to build the driveway, or to put in the driveway.
Was this property being co-developed between JM Homes and Victor McCleve?
No, it was not.
Okay, so describe that relation for us, would you?
William McCleve, who is the principal for JM Homes, he used to own the property. There were multiple properties, used to own the property. He sold them to his father, Victor McCleve, and then Victor McCleve hired his son's company, JM Homes, to build the houses.
Does the record reveal that Mr. Corrigan or anyone else from Empire knew the relationship between William and Victor?
Yes, the administrative law judge made specific findings that Victor McCleve was the owner of the property and that Mr. Corrigan knew that Victor McCleve was the owner of the property.
What I'm getting at is, did Mr. Corrigan know they were father-son?
Yes.
Now, I don't remember if that was in the ALJ's findings. Maybe it's just assumed throughout.
Yeah, and it was. It was the relationship was there. It was just assumed. It wasn't a particular finding, and that particular relationship wasn't really important to the finding. Where it comes in is the question of Victor McCleve hires a subcontractor to put in the driveway. What the administrative law judge said is it wasn't unreasonable for Empire to believe that Victor McCleve was acting on behalf of JM Homes when he hired him to do the driveway. And that's where the belief of whether Victor McCleve was the owner comes into play. Because if Victor McCleve was a complete stranger to the transaction and then comes in and contracts on behalf of JM Homes, then it would be reasonable for Empire to believe that Victor was acting on behalf of JM Homes.
But did Empire, to be consistent here, know all the machinations going on between William and Victor McCleve and between JM and William and JM and Victor? I mean, did Empire know that there was an agreement between the two of them that Empire wouldn't be asked to do the driveways and sidewalks?
I don't know if there was an agreement, and just to clarify, there was an agreement that JM Homes wouldn't do the driveway and the
An
sidewalks.
agreement with whom?
Between Victor McCleve and JM Homes.
So if there's that agreement, was Empire ever advised?
Right, and there's no evidence that Empire was ever advised of that.
Thank you.
What we have is that every contract that JM Homes entered into with Empire was signed by William McCleve. It was a written signed contract. Victor McCleve was out on the property, and he was the one that Empire dealt with a lot because Victor McCleve is the owner of the property. He was out there doing the building, working on it also, and he hired JM Homes to do the driveway. There was never any discussion, or at least never any evidence presented that there was any discussion that Victor McCleve was hiring hiring Empire on behalf of JM Homes.
Why is it not a reasonable assumption, though, under the facts here, that was the case? Assumption on the part of Empire.
I'm not concerned about whether it's a reasonable assumption, because even if it was a reasonable assumption, that doesn't create apparent authority. Because to create apparent authority, you have to have an action by the principal. William McCleve or JM Homes would have had to have done something to make Empire believe that Victor McCleve could contract on their behalf. And the law specifically says that no actions by the agent can create apparent authority, only actions by the principal.
Well, that's the traditional rule that I remember learning as well, but we have cases that say if the principal negligently or even perhaps just inadvertently induces third persons to believe that someone is their agent. So it may not require an intentional overt act, but if in this case if JM had reason to believe that Victor was dealing with Empire, that may have misled Empire into thinking Victor was their agent.
Yes, except every contract JM Homes had with Empire was in writing, signed by JM Homes. This one was not in writing. It wasn't in writing, signed by anybody.
How about the building permit? The building permit says, JM Homes, and the person applying is Victor.
Yes, Victor was the owner of the property, and JM Homes was the general contractor.
So,
That makes sense.
go ahead, I'm sorry.
Doesn't the building permit say the contact person for JM Homes is Victor?
We have that somewhere.
I do.
Maybe my recollection's wrong.
Maybe I don't.
And I will tell you, one of the problems, I understand the point that you're getting to with the
The
building.
building permit, the contractor is JM Homes, and the contact is applicant Victor McCleve.
Yes, contractor is JM Homes, and the applicant was the owner of the property.
Applicant contact applicant. So you're saying that that doesn't mean that, and then but why isn't the fact that when Empire is dealing with the earlier contracts, it's having communications with Victor,
Yes.
right? And normally you would assume that, I would think that it would be reasonable that if you're dealing with if the sub is dealing with the contractor, he's not going to take orders from the owner who's not the agent of the contractor. He's going to take orders from the contractor.
Yes.
So the course of dealing was Empire comes in, has a contract, Victor's on the site, Victor's telling him to do certain things or giving him advice. Victor must be there must be an assumption that Victor's the agent for the contractor, for the general contractor, because normally a subcontractor's not going to say, okay, contractor tells me to do X, and I get there, and the owner, who's not related to the contractor at all, tells me to do Y. I'm going to listen to Y. They're not going to do that. They're going to go back to the contractor and say, I gotta know who I'm reporting to. So here, Empire is doing contract work for JM Homes, has a contract with JM Homes, and the person on the site, Victor, is giving them instructions and responding to questions and helping direct things. Why isn't that an apparent, and JM Homes is fine with that? Why isn't that creating an apparent agency?
Under that set of circumstances, there could be. The problem with that set of circumstances, those aren't the circumstances that we had here. There was no evidence, not even any allegation that Victor McCleve was the one out there on behalf of JM Homes, or with regard to the contracts which JM Homes was in, was giving any directions or in any way directing Empire on that.
Did Victor make payments for some of that work that were accepted by Empire and credited to JM Homes?
Yes, Victor made payment for all of the work that was done on the
Why
property.
wouldn't, but Victor wouldn't be paying for that as the owner, the contractor would be paying. So if Empire comes in and says, I contract with JM Homes, I want to get paid, presents the bill, and Victor comes back with the check and says, here's the check, why isn't that enough to have a parent agency?
Because it wouldn't be unusual for the owner of the property to be paying the bills that are being, for the work that's being done.
Skip the general and go directly to the sub?
Well, skip the general, go directly to the sub, or if you are doing if you have a construction loan, it might come directly from the construction lender. I mean, there are lots of circumstances where it doesn't come directly from the general
Am I
contractor.
correct that the bills were presented to JM Homes?
I don't know where the bills were presented. My presumption was that they were mailed, but I don't know one way or the other.
And then when the checks came back and presented by Victor to the subcontractor, whose account was it rendered on? Was it Victor's account, or did it say JM Homes?
The bills were paid through Victor's account.
And the JM Homes invoicing was credited by Empire for in receipt of the money.
Right, the invoices were, right, correct.
So JM Homes, you're saying JM Homes never issued a check?
I'm not aware of any evidence that they did at all. The only payment evidence that came in were payments from Victor McCleve.
And are you saying that Victor did not direct the activities of Empire on site?
He did not.
Tell me about the driveways and sidewalks.
The problem with the driveways and sidewalks is they're the wrong color.
And what I'm saying is, there was an agreement between JM and Victor that JM was not going to be responsible for sidewalks and driveways, correct?
Right, Homes.
So factually, what happened then?
JM Homes, in the contract, which we don't know if Empire was aware of that contract, but JM Homes was responsible for the structure itself, the building. Everything beyond the structure going out that would include anything for patios, landscaping, driveways, sidewalks, everything. JM Homes was not, Victor did not hire JM Homes to do that.
Who did the driveways and sidewalks?
Empire Builders did the driveways. The sidewalks, I think, were done by the association.
At whose direction?
At Victor McCleve's direction.
So the contractor is JM. The contractor is JM. Empire doesn't have any knowledge of these things going on behind the scenes between JM and Victor. JM Victor goes to Empire and says, hey, Empire, in your contract with JM Homes, I'm going to direct you to go ahead and do the driveways and sidewalks.
No, because there was no contract with JM Homes for Empire to do any of that. Victor McCleve went to Empire and said, Empire, I want you to put in a driveway for me. I will pay for the materials on my credit card, and then they put together an arrangement for Empire to take in trade some leftover building materials for the labor to put in the driveway. So Victor McCleve paid for the materials on his credit card, and Empire put in the driveway. During the whole time that the driveway was put in, there was never any discussion related to JM Homes. There wasn't even an allegation that Victor McCleve said he was doing it on behalf of JM Homes or JM Homes wanted this done. There's zero connection between JM Homes and Empire other than Empire's assumption that when Victor McCleve asked for the driveway to be built, he was doing it on behalf of JM Homes.
Another way of saying that is there was never any clarification for Empire's benefit as to whether or not Victor was directing his conduct in regard to JM Homes or in regard to his personal wishes.
That is correct, and the name of the case escapes me now, but I do have it in my brief, and that's where you get to the idea that it's incumbent upon the person who wants to create apparent authority to stop, look, and listen, and to make sure that authority is established if there's some question or any ambiguity about whether it has been. Here we had the hiring of a driveway. JM Homes is never discussed in any way whatsoever. And Empire agrees to do the driveway with Victor McCleve paying for the materials directly with his credit card, and they're trading off material in exchange for the services or the labor of the driveway.
Understand something. JM Homes contract with Empire, and Empire agrees to take on the project. The construction project.
Well, not the whole construction project. He was
But not
hired
the
as a subcontractor to do certain things, yes.
Robert Corrigan from Empire does not communicate with JM Homes during the course of the project. Instead, he communicates solely with Victor.
Yes.
And you're saying that, and then when he gets paid, when Empire gets paid by Victor and credits JM Homes, credits the bill that was submitted to JM Homes, you're saying that in no way creates an apparent authority.
It does not create an apparent authority for Victor to be able to enter into contracts for JM Homes, because when it comes to the contracts, which is the most important part here, there were 5 other contracts that Empire entered into with JM Homes, and they were all done the same way, all in writing, all signed by JM Homes. And then when the driveway is built, there's no discussion at all about JM Homes. And Victor McCleve, by the way, was out there with a whole bunch of other contractors and a whole bunch of other, doing lots of other bits of work. Basically, he was building it himself, but hired a general contractor for the structure.
But the only difference then is that when it came down to pouring the concrete for the driveways, there wasn't a written contract between JM Homes and Empire. That's the only difference.
Yes, it was done completely, well, no, because when Empire would make a proposal and would give it in writing to Victor, Victor would take it to William. William would either sign it or not. If William signed it, Victor took it back to Empire, and then they had a contract.
Right.
Then on this last one, Victor goes to Empire and says, I want you to put in a driveway.
Right.
He says, okay, then they put in the driveway. So it's a completely dissimilar transaction.
I'm saying is that, but everything that goes on before the driveway is that except for that, they sign a contract with Empire and JM Homes sign a contract. All the communications are with Victor. Victor pays it.
Right.
And Empire credits Holmes's account, JM Holmes's account. And the difference here is that Victor comes up to Empire and says, pour the concrete for a driveway, and Empire does it, and then that the only difference is that there wasn't that written contract signed by JM Homes.
Right, because the reasonable assumption would be that if it were JM Homes who was doing it, it would be done the same way it was done all the other times with JM Homes.
I mean, a reasonable assumption could also be that, hey, my contact's always been with Victor. Victor has been, on the job. Victor has been, the person who I've been communicating with. under the contract with JM Homes, Victor suddenly comes up and says, oh, by the way, I want you to pour concrete for a driveway. I mean, it could be a reasonable assumption.
You are absolutely correct.
We're under 2 minutes.
Okay, I'll do quick. You're absolutely correct, except that where there can be more than one reasonable assumption, it's incumbent upon the person who's trying to force the apparent authority to stop, look, and listen, and to clarify that.
And
Thank you.
isn't that, wouldn't we defer to the hearing officer on that? Because that's a question of fact.
No, it's a question of fact of did he stop, look, and listen? But it's a question of law about whether he was required to do that and who had the burden of making sure that that was the case.
If the hearing officer says, I find it would be, or not defined, but if there's evidence about what an assumption was, a reasonable assumption was based on the facts, we would defer to the hearing officer. If one party's saying, listen, under that scenario, I assumed that he was still acting for JM Homes. The other side said, well, I don't think that's a reasonable assumption because I didn't have a written contract. It's up to the hearing officer to balance that evidence and decide what a, quote, reasonable assumption is.
That is correct. That would be a factual decision. You get discretion and you'd give deference to what the ALJ. The difference here, though, is the next question should be, did JM Homes do something to establish and to clarify that, and did the ALJ apply the proper standard? Because when he made the decision, he wrongly applied the law. What he said is we can look just at the agent's activity and not put any burden upon Empire to make sure that there's some clarification if there's any question at all.
You had 6 seconds to your second point.
My second point is regarding fees. In the response, the appellee requested fees, saying that this is a case arising out of contract, and it isn't. It's a statutory disciplinary proceeding where the question is, does he get disciplined? It's not a contract case.
There's a decision on that. Huh? Isn't it written by?
It's a very good
It's
decision.
a very good decision. Isn't that the Keystone? Is that Keystone Floor?
I've heard of it.
I think you wrote that. I think I was on panel with you. Okay, thank you.
Thank you very much, Mr. Tafoya.
Good morning. My name is Mark Schreiner. I'm here representing the Applee Empire Builders. We're here to ask this court to affirm the judgment of the administrative law judge and the Coconino County Superior Court. The three issues brought up by the appellant stating that the ruling of the administrative law judge should be overruled are on agency, on waiver, and on rendered services under the statute 321154A11. Initially, I think it's important that we look at who the actual owner is. Why it's important for the owner, because an owner would be exempt under the contractor statutes to do the activities that Victor McCleve did. The deeds on the property were allowed into evidence at the Superior Court level based upon motion of myself to supplement the record. The ROC in his decision even states that there's only an implication that Victor bought the properties from JM Homes. So I simply did a title search, and we found out that during the entire relevant period, the owner of the real property was JM Homes. The appellant had an opportunity in Superior Court to supplement the record, just as I did with the deeds, to try to controvert that. It is uncontrovertible that at the time of the contracts that JM Homes was the owner, and the assertions that
Does this, excuse me for interrupting, but does this matter to the apparent agency issue?
Well, yes, it does. I mean, one, he says if you're the owner, you act like an owner, you do things as an owner, and that would place my client on notice that he wasn't a subcontractor for JM Homes.
But even more, if Victor McCleve is not the owner of the property, but JM Homes, the purported contractor, is the owner of the property, what position does Victor McCleve fill?
Well, I think that he was illegally contracting, to be honest with you. The contract between him and J.M. Homes provides that the general contractor is responsible for all the matters in the interior of the home, and the construction in the exterior of the home, the landscaping, the driveways, the structural matters was only for Victor McCleve. Well, I believe that one is an illegal contract. It's attempt to usurp the contractor statutes by placing the duties of a general contractor on Victor McCleve just as a person.
I follow you, but I'm not sure how that matters to the issues that we have.
Fair enough, but I do believe when you make an assertion that that Victor McCleve is the owner and that you should be treated like an owner, that we needed to address that to show the fact that he was not the owner. The other matters that I think really confirm the agency argument are the building permit. The building permit is required by statute. That statute says that you will fill out that application under penalty of criminal law. So on all 3 building permits, Victor McCleve filed as the agent or the applicant for J.M. Homes.
Well, now that's defined or dictated or revealed by statute. I'm not sure it's revealed just by looking at the building permit. We have a copy of one of them here, and it says, as I think Judge Kessler already said, it says contractor is J.M. Homes. It says applicant is Victor McCleve, and the address of the home, I assume. Why isn't that just saying that he's the guy living there?
Well, one, he has a right under that statute to declare that he is exempt from the contractor statutes by stating he's the owner, and he failed to do so. So the only way he would have been able to get the building permit is as an agent of J.M. Homes. You can either get it as a homeowner, and he was not a homeowner, and he has the exact right in the application to state that he's the homeowner, and then he would be exempt under certain matters. But when you're dealing with the situation where you have an unlicensed contractor who is developing 3 homes, doing the outside construction and the inside construction, certainly agency applies. And I think also that the record was replete of incidences that showed that Victor McCleve was the owner.
Victor McCleve was the owner?
No, that Victor McCleve was the agent, excuse me, Your Honor. But one, you need to look at the activities that Victor McCleve performed on behalf of J.M. Homes. It was clear from the ROC record that he represented J.M. Homes at the ROC complaint filed against my client, the original one, where there was a corrective order. So he was the agent for there. He was also the agent to make contracts. All this is delineated in my brief with direct cites to the record, where both parties, William McCleve, the son of Victor McCleve and the owner of Appellant LLC, directly admits that his representative was Victor McCleve at prior ROC actions.
So, at the ROC hearing on the complaints about workmanship by Empire, Victor McCleve appeared as J.M. Homes?
Yes, he was actually at the construction site and met with the ROC inspector and my client, Bob Corrigan, to go through the punch list of the requirements of the corrective order. I believe that's Exhibit R2 to the...
Who was the complainant in regard to the ROC?
Oh, that would have been J.M. Homes.
Okay. So J.M. Homes is the complainant. Empire is the respondent.
Correct.
And J.M. Homes is represented at that proceeding by Victor McCleve, who apparently has the ability at those proceedings to concede issues, to mediate.
To actually act as the general representative of J.M. Homes. He was there with the ROC inspector who inspected the premises, and they went through the things on the punch list that my client was required to do, and he acted as representative of J.M. Homes for that matter. There wasn't a hearing on the original original complaint filed by J.M. Homes on the thing. They were just corrective work orders, a few things that need to be done.
Council, I've spent a lot of times at a lot of work sites with ROC inspectors. And my question for you is this. At those hearings, to my understanding, the representative of the complainant there needs to, A, assert the position of the complainant, also enter into stipulations, if possible, regarding workmanship or workmanship problems or concessions that are raised at the on-site inspections, correct?
That's correct, Your Honor.
So as the proceeding went on at this ROC on-site inspection, Victor McCleve was able to make decisions on behalf of JM Homes as to the issues challenging the workmanship of Empire.
That is absolutely correct. He was the only representative of JM Homes there. They went through each one of the things contained on the punch list that needed to be corrected, and it was approved by Victor McCleve.
Was that before or after the issues that are pertinent here, the issues of whether
That was
Empire and Mr. Corrigan had reason to believe that Victor was the agent of JM?
That was long after. The inspection was in 2012. My client completed construction in spring of 2011, including the driveways. Okay, and so he's only, I would agree with counsel that he only dealt with Victor McCleve, but the facts are that he would submit invoices to JM Homes. JM Homes would pay some of the invoices, and then Victor McCleve would pay some. My client certainly had no knowledge of the relationship between father and son. His only thing, and he always dealt with Victor McCleve, that Victor McCleve represented JM Homes. And I think that's a fair assertion when JM Homes is taking credit. They admitted they contracted, JM Homes admitted they contracted with my client to do the cabinetry work. That's what the original ROC complaint was.
Who signed those contracts? I guess there were 5 contracts?
That is correct. They were signed by JM Homes.
Well, corporations can't sign them.
Well, it was signed by William McCleve on behalf of JM Homes.
Doesn't that send a signal to Empire that, hey, JM is William, not JM is Victor?
Well, but when you have representatives at the site all the time, the general contractor can't be on each construction site when a sub is there doing work and it's taking instructions from a person on all 3 sites. One, he has the right to know he's not a general contractor and he's not the owner. The only thing he's left to be is the agent.
So this was a contractor-driven construction project.
Absolutely.
And he was not building, and Victor was not there as an owner-builder.
No, he wasn't there. You have to be the owner. And so the only thing that the administrative law judge could find was that he was the agent. Otherwise, he would have been contracting without a license.
By the way, on the record, maybe you can help me. We have 1 or more of these building permits, but I understood from your comments a few minutes ago that the application might be pertinent. Does our record contain the applications for the building?
I believe those were exhibits. Again, I was at a disadvantage. I wasn't at the original ROC hearing.
Understood.
And you always feel like you're a little behind the thing. So I can't state from the hearing itself, but I do believe that is on file. The next issue would be the preliminary 20-day notice sent by my client to JM Homes. My client did a title search. It was determined JM Homes was the legal and lawful owner. He sent the preliminary 20-day notice to JM Homes. They have a direct right under statute to controvert the information in the preliminary 20-day notice. He failed to do that. When you fail to do that, the statute directly says that you're stopped from declaring you're not the owner. So they're trying to take 2 positions, is that Victor McCleve is the owner even though there's no deed on the property, and that William McCleve, even though he's stopped from saying he's not the owner, now isn't the owner. They've given them every opportunity to try to clarify the situation, but my client's in a case where you enter into contracts, he gets payments from JM Homes, inspection work at the ROC. Inspection was done by Victor McCleve on behalf of JM Homes. You got to remember, JM Homes is the one who filed the complaint against my client. I also find it interesting that JM Homes admitted they owed my client $818. There's such an intermixing in between payments, authority, non-authority. The only way that you can reasonably look at this is that Victor McCleve had apparent or actual authority, is my position, to represent. You can't take a position of being at the inspection site, representing Empire Builders as the complainant, and then switch it around.
I sense that Mr. Tafoya's argument is that JM itself has to do something to hold out or indicate or lead Empire to believe that Victor is JM's agent. What did, well, first of all, is that the law? And if so,
that is the law. I would agree with that.
What did
But that's
JM
on
do?
actual authority. This is apparent or actual authority. That's on apparent authority. But even under the apparent authority, when you have Victor McCleve represent you at an ROC inspection site.
But it's after the fact. It's after the fact of the issues here. So does it? How does it contribute?
Oh, well,
to
then he was
apparent
just on the
authority?
job site and instructing him to do things such as the cabinetry work, the stairs upstairs had some
And he'd still
problem.
get paid.
Excuse me?
And he'd still get paid.
He who?
Empire. Empire would still get, in other words, Empire contracts with JM Homes to do the inside work.
Correct,
Victor's there supervising it.
correct.
He'd submit the bill saying, I want to get paid, and he'd get paid.
Most, yeah, from JM Homes, except for here, yeah, obviously, yeah.
Right. But generally, and so that, what you're saying is, that's enough, because you submit a bill, if I understand your argument, if the sub submits a bill to the general contractor, and then in response to the bill, he gets a check, whoever writes it, and he has a contract with JM Homes, then it's presumed that JM Homes is acting, it's a reasonable assumption that JM Homes is acting for, that Victor is acting for JM Homes.
I would agree with that analysis, exactly. I think the payment is just one of the factors, though, that you need to look at. The other argument that the appellant attempts to have this court overrule the ALJ and the Coconino County Superior Court is the waiver argument. He couches it in terms of a collateral estoppel argument, but it's clear that Victor McCleve and HM Homes had 5 different methodologies available to them, and that they failed to exercise any one. The first one obviously was from the ROC inspection, where they said this case is finalized not unless you file within 10 days. They failed to do so, and he also passed inspection. That also goes to the merits of they want to submit a defense that it wasn't done properly, said, ooh, you should have allowed all this evidence. The ALJ, of course, allowed the evidence in, and there was no evidence of any kind of substandard workmanship.
There was corrective action, that corrective action had to be taken, right?
No, not on the driveways. That's where I'm surprised. They got the COA on the driveways and the Flagstaff Ranch, a $1 million resort community up in Flagstaff. I'm very familiar with their architectural committee, issued no violations to JM Homes, Victor McCleve, or the homeowners.
The non-payments had no relationship to, the failure to timely pay had no relationship to the corrective actions.
That is correct. The corrective actions were all stuff that was in the interior of the house. This action bought through 321154 was exclusively for the driveways. I think there was a couple of little extraneous matters included in there. But when the JM Homes shows up and admits they owe money under the the first thing they say is admit they owe money under one of the invoices. How are we supposed to separate? I just don't think that is fair. And certainly they had all the avenues. They could have requested a citation. Victor McCleve actually filed an ROC complaint, and he chose not to prosecute. He received notice from the Register of Contractors saying, hey, you haven't responded, we're going to dismiss.
What was his capacity?
Victor, I don't think he had standing to even bring the ROC complaint, and that's why he didn't prosecute.
Did he assert to be the contracting party?
Yes, he did.
Contracting with who?
With my client, Empire Builders.
And was there an agreement between Victor McCleve and Empire Builders?
No. Victor McCleve just chose not to prosecute his complaint he brought exclusively on the driveways. And he received notice from the ROC saying, hey, if you want to bring it up, you have a right to. And so there was a 6-month period between when Victor McCleve brought his individual ROC complaint against my client and when the hearing was heard here. In between those 6 months, he had all kinds of avenues of relief available to him to address these alleged substandard workmanship.
And that's what I wanted to get to, and I know we don't have a lot of time left. We've already talked about the fact that J.M. Holmes was the contracting party with Empire. J.M. Holmes owned the property. J.M. Holmes, this was a contractor build, not a owner builder.
That's correct.
Build. And Victor McCleve directed the actions of Empire under the contract between J.M. Holmes and Empire, correct?
That is correct, for the interior of the house.
And when there was an assertion of workmanship problems, J.M. Holmes brought the complaint against Empire Builders, and Victor McCleve was their prosecutor, their I'm trying to stay away from the word of agent. There you go, representative for purposes of pursuing J.M. Holmes' interests.
That is absolutely correct.
Thank you.
And so I believe that they've obviously waived their right to proceed. And I've only got 20 seconds left. I'd ask the court to affirm the decision of the ALJ. It is based upon substantial evidence. When you apply the standard of review, I think that there's more than substantial evidence to show the agency and that J.M. Holmes needs to pay off this bill. And I'd also request the court award Empire Builders reasonable attorney's fees and costs. Thank you.
Thank you both very much. We're out of time. We might be tempted to take a little further time, but we have the next arguments due to start at 11 o'clock. So we'll take this matter under advisement and recess for a moment to allow the next case to come up. Again, thank you both.
Thank you, Your Honor.